Good afternoon, everyone. My name is Séamas Gray, and I'm here to talk to you about key practice points and potential pitfalls on my catchily named Insolvent Estates of Deceased Persons. If you'll forgive, please, the rather dull title, I'll take you to the source in a moment as to where that comes from. I should hope that it will be of significant interest to everyone listening. It'll certainly be of interest to anyone dealing with an insolvent estate now. It should also serve as a rather stark warning to personal representatives and advisors who are dealing with estates that are potentially insolvent. Thirdly, with regard to this time of aging demographics, it should prove as a cautious reminder for both IPs and private client lawyers who are dealing with older clients who might be seeking to dispose of assets, whether for tax reasons or otherwise, or who may be of doubtful solvency. Fourthly, it's quite technical, so anyone with a technical mind, which I am and enjoy, will really like getting to the bottom of some of these curious points that lie within the legislation. And finally, those with a sense of fun, because it's amazing what actually washes up and comes out of the woodwork in relation to an insolvent estate post-death. So taking you to the topics, today's seminar is intended to cover, firstly, with a broad brush approach, to give you an overview of insolvent estates. Secondly, I'm going to take you to some of the similarities and differences within traditional bankruptcy and how insolvent estates are similar and where they diverge, sometimes in small degrees and in other times in significant degree. That takes me neatly to the key potential pitfalls facing an advisor looking at a potentially insolvent estate. And finally, I will take you through the relevant case law in relation to insolvent estates and what helpful tips might be received by private client lawyers or insolvency practitioners or their advisors in dealing with insolvent estates. Taking you firstly then, as you can tell, the relevant provisions that amend the Insolvency Act 1986 come from this incredibly dully named Administration of Insolvent Estates of Deceased Persons Order 1986, Statutory Instrument 1986 of 1999. And for the purposes of this presentation, I refer to this as the order as we go through the presentation. The order is divided into various sections. The Article 3 of the order relates to persons who die before the presentation of a bankruptcy petition. That is the key part of this presentation, as it is in relation to persons of this nature that the key differences with ordinary bankruptcy lie. Article 4 of the order, Administration of Estates of Deceased Persons outside bankruptcy, I'll touch on briefly. There's not a huge amount to say about this, but I will cover it later as to how it's possible to deal, this is for PRs, how it's possible for PRs or other persons to deal with insolvent estates without actually placing the deceased into bankruptcy, although how that's referred to I will come back to in a moment. Article 5 of the order relates to the administration of estates of persons dying after the bankruptcy petition. Now, this is not something that many of the IPs listening and advisors will not have experienced before, because it's not massively different to normal bankruptcy. If the person dies after the bankruptcy order, as the advisors will know, the bankruptcy is dealt with some minor modifications, as if the bankrupt was still alive. If the debtor dies after the order, but before the statement of affairs is filed, then typically the personal representative or such other person as may be appropriate will be asked to prepare the statement of affairs. If it happens after presentation of the petition, but before service, then an order can be obtained for service on the personal representative. If it's after presentation and service, but before the order, a person wishing to defend can be given standing either by an order being made that is reserved on the personal representative or such other person, or a representation order can be made. As I said, neither of them, in relation to Article 4, in relation to Article 5, it's not massively different to how a normal bankruptcy runs, and so I do not propose to go into great detail on that, as many of the listeners will already be familiar with that. The key part of this presentation, as I remind you, is to talk about what happens to persons who died before presentation of a bankruptcy petition. That is the subject that is the most tricky in relation to the order. So let's first look at where similarities lie. It's very much akin to personal bankruptcy, but there are clearly some necessary, as will be unsurprising to anyone listening, there's some necessary amendments to the Insolvency Act. There is still a statement of affairs, although unsurprisingly, as the debtor is deceased, this is typically done by the personal representative. But a lot of the powers that trustees in bankruptcy or their advisors will be familiar with continue to apply in an insolvent estate administration. Powers under Section 366 of the Insolvency Act, for example. These are provisions, as listeners will potentially be aware, where a trustee in bankruptcy is entitled to ask such persons who may have information concerning the business dealings or affairs of the bankrupt to provide information, and those provisions apply equally in relation to an insolvent estate. Indeed, this is something I have one on at the moment where for quite a large part of the insolvent estate, we have been dealing with inquiries under Section 366 of the Act so that the trustee is able to make an adjudication on the relevant debt. In relation to Section 285 of the Act, and this is something again that many of the listeners will be familiar with, it enables the trustee to apply for a stay of proceedings. It's not on the slide. I should also mention that the usual course in an insolvent estate is very similar to that with bankruptcy, where the OR is initially presented, but one can apply for an order appointing a trustee in bankruptcy immediately where this is considered appropriate. And again, I have another matter where that indeed was done. So one has to get familiar with some of the terminology. Again, these are not massive differences and will come as little surprise to many of the listeners. The bankrupt estate becomes the deceased debtor's estate, and a bankruptcy order becomes an insolvency administration order. Administration of the estate by a personal representative, that can be a non-insolvency practitioner under court supervision pursuant to administration order, can also be ordered. So this is effectively an insolvent estate that is being administered outside of bankruptcy, but it's under the supervision of the court. The court dislikes doing this because, as listeners can imagine, it requires a huge degree of involvement by the court, and it is not necessarily the cheapest way to go. The next, this is going back to Article 4 again. The personal representative can administer the estate. The personal representative doesn't have to be an IP, it could just be the normal personal representative that was initially appointed as the PR. But if the personal representative does choose to administer the insolvent estate, he or she has to do so in the same way as if an insolvent administration order had been made. Now, as the qualified IPs listening will imagine, and their advisors, that can be rather difficult. There are very tricky technical aspects that an IP is familiar with that a non-IP will not. and will require advice as to how and what to do in relation to the administration of the estate, which once again does not necessarily mean a cheap administration of the estate, but it can be significantly less than putting it into a formal insolvent estate administration where there are significant professional fees being incurred. So other similarities, there is a similar statutory waterfall, but one must remember that in addition to the usual statutory waterfall of debts, in addition comes in a new special type of debt, which are the reasonable funeral, testamentary and administration expenses, which have priority over preferential debts. So where does this leave the fees of the personal representatives? That can become quite tricky. You have solicitor executors quite often who have incurred significant fees. You have accountancy or solicitor's advice that's been requested by the personal representatives, and I'll come later to dispositions in relation to the insolvent estate, which is the stark warning that I mentioned at the beginning of this presentation. Where one is looking at an insolvent estate and there's a PR already appointed, what's the most appropriate course? And that needs to be considered. Is there enough money in the estate to cover both a trustee in bankruptcy, a trustee in bankruptcy's fees, as well as the personal representative costs in many cases already incurred? And that is a fine line. It can be risky for them to do so, but subject to the nature of the estate, it might be the best way and the cheapest way to administer the estate. But quite clearly, a personal representative in such circumstances is going to need assistance from an insolvency practitioner to ensure that they conduct the estate as an insolvent estate in the same way that the insolvency practitioner would do so if an insolvent estate administration order had been made. And then you have, of course, the bequests and the beneficiaries under the will. Someone's died, they're very pressing and they're hoping to receive money from the will. They don't always fully appreciate that the estate is insolvent and effectively not too dissimilar to corporate bankruptcy, or insolvency, should I say, rather corporate liquidation. A beneficiary under a will can be looked at in a similar way to shareholders in a corporate liquidation, where they rank well below the creditors of the insolvent liquidation and here the creditors of the insolvent estate. But I will touch upon the balancing act between beneficiaries and creditors later in the presentation. So what other sort of little differences might there be? It's also worth remembering that section 278B of the Insolvency Act, which states that bankruptcy shall continue until the debtor is discharged, and section 279 of the Insolvency Act, which stipulates that the bankrupt shall be discharged after 1 year, are not applied to deceased estates by the order. So to be clear, there is no discharge. There is no discharge period. There is no applications to delay discharge. Basically, once a deceased estate is bankrupt, i.e. an insolvent estate administration order is made, it will always be bankrupt. The only way to get out of it is if the entire bankruptcy or insolvent estate administration order is annulled, which is possible. It's also worth just touching for a moment, as I mentioned before, on IVAs, that is individual voluntary arrangements. The order and how it applies to the Act, to be quite honest, is a little bit of a mess, and it's not perfectly clear what was intended by the legislation. Considered opinion is of the view that an IVA is to end on a debtor's death. The reason I say appears to end on a debtor's death is because there are references to actions that can be taken in relation to, by a personal representative in relation to an IVA after death, which indicates, or it could be said to indicate, that perhaps an IVA is intended to continue after death, but it is quite clear, or learned opinion on the subject seems to believe that the legislation is intended to come to an end automatically on the death of a debtor, even where you have a pre-death approved IVA. But there are the legislation allowing personal representatives to make applications in relation to supervisors of the IVA really must relate to trust, to assets held on trust under the terms of the IVA. So now we get on to some of the differences, some of the bigger differences. It's worth noting, so section 421A of the 1986 Act, which relates to joint tenancies, as trustees or their advisors on the webinar may be familiar. This is where property was held on joint tenancy at death. In normal circumstances, under property law, the surviving joint tenant becomes the owner of the entire property. Under the Insolvency Act, there is provision under section 421A to allow a trustee in bankruptcy to make an application to require that the surviving spouse contribute to the estate, or to the bankruptcy estate, I should make clear, an amount that is equal to the value of the property, or the joint tenant's half interest in the property. Well, I suppose if there's more than two joint tenants, it'll be a third, or whatever the number may be, before the bankruptcy order was made. Here the change is quite small, but does have some significant differences. Here the change is that it's not when the bankruptcy order is made that there has to be this joint tenancy. The joint tenancy applies if immediately before the death, the debtor who is subsequently made bankrupt, or an insolvent estate administration order is made, possibly several years after the person has died and has ceased being a joint tenant, will date back to the date of death. So provided at the date of his death he was a joint tenant of the property, then these provisions apply. However, there is a restriction on this. Unlike in relation to certain other provisions of the order, which I will come to later, the petition has to be presented within 5 years of death. So in other words, if there's a joint tenancy, the debtor dies, no petition is presented, nobody believes the estate is insolvent, but it's subsequently discovered that the estate is insolvent and a petition is presented, then the date of death and the joint tenancy will kick in, will kick in, but only if that petition is presented within 5 years of death. So if a petition is subsequently presented 6 years, 7 years, 10 years after the date of death, you won't have this look back period to the date of death. The application in this case is made by the trustee again, and is the application for the contribution is effectively the value lost to the estate by the property passing to the surviving joint tenant. So some significant differences. This is more so than in relation to section 421. In many cases, many provisions of the Insolvency Act are changed to modify and apply the date of death in substitution for the commencement of the bankruptcy. So this will apply to after acquired property, so property that has been acquired not after the person's become insolvent, but any property that's acquired after the date of death. Section 328 of the Insolvency Act, well, sorry, I have defined it as the 1986 Act, so I can refer to it as that, applies to the priority of debts. So in terms of what debts rank in which priority, this will look back to the date of death, not to the commencement of the bankruptcy. Section 329 of the 1986 Act, as some listeners will be familiar, has a special provision in relation to the priority of debts to a spouse. Once again, this looks back to the date of death rather than the commencement of the bankruptcy. Excuse me. Section 341 of the 1986 Act. This, as practitioners, will be familiar. For those who are not, this applies to what are known as Section 339 and Section 340 claims. Section 339 claims being, so Section 339 of the Insolvency Act is where you have a claim as a transaction at an undervalue. And for Section 340, those are preference claims under the 1986 Act. The relevant time in both those cases, because they're limited in time, typically 2 years and 5 years, is the look-back period from the commencement of the bankruptcy. Here, that can be much later in time. The claim can be potentially brought many years later. It's not just the 2 or 5 year time period, because the look-back period will start from the date of death. So even if the insolvency does not commence for another 5 years or 10 years even, the look-back period will start from the date of death and look at transactions that can be challenged as a transaction at an undervalue, being transactions where the consideration received by the estate or the debtor in this case is no consideration or significantly less than that received by the debtor. And Section 340 claims, where you're looking at challenging, that's a preference claim, where you're looking at challenging payments to certain parties in preference to other creditors. Section 359 of the 1986 Act, again, this is fraudulent dealing with property acquired on credit. This is a provision which some may again be familiar with, where there are persons who knowingly effectively deal with a debtor who obtained assets on credit but haven't paid for them prior to the bankruptcy. That this Section 359 of the Insolvency Act, sorry, of the 1986 Act kicks in. But here the look-back period, which is 12 months, doesn't apply from the commencement. The 12-month look-back period will include all transactions that happened 12 months prior to the date of death. Some other changes. Section 281 of the 1986 Act, the distinction between provable and non-provable debts, which applies in the usual course of a usual bankruptcy, is not applied by the order. Now, provable and non-provable debts in bankruptcy, there are certain debts that are regarded as non-provable and survive bankruptcy, such as certain orders and debts and liabilities under matrimonial proceedings. Provable debts do not survive bankruptcy, and that is the public policy principle of bankruptcy, is that these debts are discharged and the debtor, upon his discharge, is released from all of those debts, whether they are paid or not paid from the bankruptcy estate. Clearly, as I referred to earlier, we don't have discharge on an insolvent estate, so the estate now must answer for all debts, whether or not they're provable in an ordinary bankruptcy. Section 283 of the 1986 Act. This is the definition of the bankrupt's estate and includes everything he then owned. Now, in a usual bankruptcy, this applies from the commencement of the bankruptcy. In an insolvent estate, this looks back to the date of death. This will have significant implications in relation to Section 284, which I'll come on to later on. Similarly, Section 382 of the 1986 Act, definition of bankruptcy debt. So this excludes debts arising after death. So what happens to assets that have been disposed of after the death of the bankrupt before the estate entered an insolvency procedure? What happens to debts that have arisen after the death of the debtor but before an insolvent estate administration order? These are rather tricky aspects, and they all really lead into Section 284. Section 284 of the 1986 Act makes void, not voidable, dispositions of property from the insolvent estate. That applies in bankruptcy, but that applies in bankruptcy after the petition. In an insolvent estate, this kicks in at the date of death. So absolutely any payment out of the estate after death, even before anyone knew the estate was insolvent, are completely void. It's for this reason that I said that at the beginning of the presentation, practitioners, not just those who are already dealing with insolvent estates, but anyone who is dealing with an estate that is potentially insolvent, needs to take stark warning, because any payments made out of that estate, whether it's for legal advice or otherwise, are all void. Not voidable, but void. And that can expose many advisors who are attempting to do an absolutely fine job, but all the payments for those advisors are by the legislation void. I will move on in a moment to how one might rectify that, but that is the starting point. And please note that such dispositions are not readily sanctioned or ratified. So what about section 2844 of the 1986 Act? That, as practitioners may be aware, provides a protection for recipients of such dispositions in good faith, for value, and without notice of the petition. That doesn't apply. That does not apply in insolvent estate administration. The order says such protections only apply until the date of death. So there's no protection at all to post-death dispositions when an insolvent administration order is made. This, as anyone listening can appreciate, can be extremely harsh. There can often be significantly long periods between a person dying and estate being administered, often for many years, and a creditor or liability becoming discovered that makes the estate insolvent, and where it then becomes necessary to petition or apply for an insolvent administration order. But how does one deal with these payments out that are post-death? So these would be void, remember? These are payments that have been made out by the personal representative after the date of death. Can the PR claim that they're an administration expense? Very rarely. Only things that would be covered would if they're reasonable and proper expenses of the ordinary administration of deceased estates. And they're very limited in that sense. What about subrogation? I've had a matter that I was dealing with where a party made certain payments which they asserted were bankruptcy debts, or debts of the insolvent estate in this case. So such debts would have to have arisen pre-death, and they paid them. What many people appear to forget is that subrogation is not an automatic remedy. It's if you pay someone's debt, you're not subrogated to that person. Subrogation is an equitable remedy, and equity does not assist a volunteer. Subrogation only applies in very limited circumstances where there is a degree of compulsion to pay that liability, such where you have a guarantor, surety, where there's some sort of an indemnity, where you've given an indemnity, or where a typical example of these sorts of contracts are insurance contracts. Obviously, an insurer is required to pay a liability, and they are subrogated to the debtor's position. Here, this is where there is a liability, for example, of the now deceased, but another party has given a guarantee in relation to those liabilities. That person, if they've given a guarantee or some sort of an indemnity or surety agreement, can potentially, once they've discharged the principal liability, step into the shoes and claim subrogation. So apart from these very limited types of justification for post-death expense incurred by the PR or such other person who's administering the assets of the deceased, what else can one do? Ratification is ratification possible? Well, let's have a look. I'm taking you first to what's considered the principal case in relation to ratification. This was a decision by Chief Registrar Baster, as he then was, back in 2006, Dick and Kendall Freeman, otherwise known as Revos, deceased. And typically, and later on in this presentation, I'll refer to it as Revos. Here, the debtor died in January 1992, but there was a long period before an insolvent administration order was obtained. That wasn't for another 8 years. The deceased here was in Lloyd's name. Not long after his death, a cash call was made by Lloyd's to the personal representative. The PR instructed solicitors to defend the proceedings. This went on for some time, from 1992 all the way to 1998, when proceedings were finally issued by Lloyd's. Very quickly after the issue of proceedings, Lloyd's obtained summary judgment and an order that the deceased was liable to Lloyd's in the sum of £1.4 million. The estate still hadn't gone into a process. No petition was presented for an insolvent estate administration order until 2000, and the order was obtained in the same year. As you can imagine, substantial sums were spent on litigation by the personal representative from 1992 all the way to and including, in fact, post-2000. So what happens to those monies? Those monies were all spent from the insolvent estate. We know, and we looked at it earlier, the estate comprises of all assets at the date of death. We've also looked at section 284, which makes it clear that any disposition from the estate is void. The PR and the solicitors concerned were not able to rely on section 284, subsection 4 of the Act. So what could they do? So they applied for retrospective, so an application was made that all such payments out were void. This is Lloyd's application. That decision was made by Chief Registrar Baster. The solicitors applied for retrospective ratification. Chief Registrar Baster, as he then was, refused. He said nothing after December the 31st, 1994 should be ratified. Not long, as we've looked above, in 1992, the debtor died. It wasn't long after that a call was made. The court looked at the costs incurred in the period up to 1994, where the PR was simply taking advice, but all costs incurred in defending this cash call from December 31st, 1994, the court considered should not be ratified. The estate was insolvent, and the PR and the solicitors knew or ought reasonably to have known that there was a high risk that this estate was insolvent, and they should have, by no later, absolutely no later than that date, have applied for an insolvent estate administration order. And on that basis, more than 6 years of fees all had to be repaid, notwithstanding that the work had been undertaken. It gets worse. That was 8 years. In Williams and Lawrence in 2011, the gap between death and formal insolvency was extreme. Here we are looking at a period of 15 years. The debtor died in 1994, but a petition wasn't presented for another 8 years in 2002. And an insolvent estate administration order was not made until 2009, so 15 years later. prior to the petition, and only 2 years, just 2 years after death, the son, who was also one of the personal representatives, acquired valuable property from the estate. The court looked at this and, applying Revos, which we've just looked at, unwound the entire transaction. Even though this was 1990, so when was it? 1996. So this was 13 years after the event. The court said the entire transaction, the property had to be returned to the estate. And the court, when he looked at it, said, and the court felt no sympathy for the personal representative, the son who acquired the property. The court said any adverse consequences that flowed from this came from the preference that the personal representatives and advisors to the family, that is the solicitors and accountants concerned, had the preference that they had to the family interests over the interests of the estate creditors. And the court had no hesitation in reversing that transaction. To continue on some further case law, which I said I would take you to. Here, as many listeners will be familiar, whether or not they're petitioners, is the estate of Jimmy Savile and the notorious circumstances that arose post his death. In this case, there were numerous undetermined claims for personal injury. It was impossible for the executor to know then the number, the scale, the value, sorry, I've said number twice, the number, scale, or value likely to be substantiated. There were lots of, as people may be aware, there were lots of claimants coming out of the woodwork saying that they had been abused in one way or another by Mr. Savile. And the number of such claimants was very large, but the question was, nobody really knew whether these claims could be substantiated or not. Now, the executor and the representative of the PI claimants were concerned that a large quantity of the estate would simply get used up in legal fees in dealing with all of these claims by court litigation. So the executor and the representative, well, I should say representatives, because there were several of the personal injury claimants. The personal injury claimants, let's not forget here, are the creditors in the estate, agreed to a scheme for an out-of-court claims assessment to try and deal with such claims as expeditiously and efficiently as possible. An application was made by the executor for retrospective validation of all the costs incurred in dealing with these PI claimant representatives and agreeing the scheme for out-of-court claims assessment, which again, listeners will appreciate would have been very considerable. The beneficiaries under the will opposed this. Now, if one just looks at a strict Revos, which the beneficiaries referred to, they said that under Revos, all of those costs incurred, all the payments to the executors and their legal representatives should be quite simply void, because no application for no application for ratification was made. The beneficiaries' claims did not succeed, but it went to the Court of Appeal, and the Court of Appeal distinguished Revos in the very exceptional circumstances of this case, in that at the time when the application for retrospective validation of costs was made, the assets of the estate far exceeded the proven liabilities of the various personal injury claimants that were appearing from the woodwork. More to the point, this was what was set up was agreed between the executives and the persons that Revos is there to protect, the creditors. This was the PI claimants' representatives. So all of these costs were incurred not contrary to the interests of the personal injury claimants, but with their interests at heart. Now, the beneficiaries under the will are much further down the food chain, and for that reason, the court distinguished Revos and allowed the executives in this case to obtain retrospective validation. The fact that it went all the way to the Court of Appeal should be a reminder to listeners how difficult it will be to get retrospective validation. It is very, very difficult and should not be considered or taken as a given. Having just talked to you about the Saville case, I thought this was a good juncture at which to talk about how personal representatives and trustees, if so appointed, dealing with insolvent estates need to deal and consider the interests of creditors and beneficiaries, which I did allude to earlier on in the presentation. As stated earlier, the relationship between creditors and shareholders is very much akin to corporate insolvency, where you have directors who are looking at the best interests of the company, meaning its members and shareholders. Where here, a personal representative is trying to achieve, as all personal representatives must, trying to do the very best for the estate. What does do the very best for the estate here mean? Very best for the estate, where there's clear insolvency, means the personal representative or the insolvency practitioner needs to be looking to the interests of creditors as absolutely paramount. Where there is doubtful solvency and not clear and absolute insolvency, it is quite right and proper for a personal representative to look at the interests of both creditors and beneficiaries. Clearly, the more doubtful the insolvency, the more the interests of the creditors will be viewed as prevailing over the interests of the beneficiaries. What's extremely important is for personal representatives. Trustees in bankruptcy will already be familiar with this and will not fall into this trap, but personal representatives need to be extremely careful to resist the temptation to assume that the interest of beneficiaries is equal to the best interests of the estate. The reason for that is, as many listeners can imagine, that it's not uncommon for claims to be made against the estate. And obviously, the lower those claims are, or the better those claims are resisted, the more money is left to go to the beneficiaries. However, one has to remember that a creditor might have a very well-founded claim that is clearly going to be adverse to the estate. That was the case in Revos, which we went to. So, notwithstanding that the beneficiaries of the estate are encouraging and supporting a personal representative to resist such a claim, if the personal representative does so, he risks all of his costs being incurred, being declared void under Section 284 in accordance with the decision of Chief Registrar Baster in Revos. So how does one go about ratification? Well, ratification can be obtained in various manners. Ratification can be prospective, and that applies even before a petition for an insolvent administration order, an insolvent estate administration order, has been made. Or it can, of course, be retrospective. Retrospective ratification, as we've explored, is very difficult where the estate is of doubtful solvency. To be very clear, once you reach a point where the estate is of doubtful solvency, an application needs to be made, because any costs being incurred after that time are likely to be considered void. So what about where we have an estate? This is in exactly these circumstances. There's no insolvent estate administration order. There's no application for it. There's no petition. But we're looking at an estate and we think, oh, hang on a sec, this is of a doubtful solvency. Well, a pre-petition prospective ratification application can be made. It's as many private client practitioners here will be aware. One in an executor can apply for what's called Beddoes relief, which is where an application is made by an executor to get sanction for what he is proposing, such that the beneficiaries in the estate can't later make a claim against him. And pre-petition prospective ratification is very similar to that. But here, of course, we're looking at protection from the estate creditors, not from the estate beneficiaries. And it is also important to note that the court to which such an application should be made is one with bankruptcy jurisdiction for the debtor. As insolvency practitioners and their advisors listening will know, that, of course, when one petitions for bankruptcy, one has to apply to the correct court with bankruptcy jurisdiction for that debtor, which typically means where he has lived or conducted his business within the preceding 6 months. So, right, that's all the technical bit. And I did say that the technical side, for those who are listening, is extremely interesting and it is very technical. I should hope that the presentation has proved a stark warning for anyone who is dealing with an estate of doubtful solvency. Quite frankly, the moment one is dealing with an estate of doubtful insolvency, all sorts of warning lights should be going on and specialist advice on the subject should be obtained. But I also said that they can be very fun. I mean, look, you've got to have a sense of humour in this stuff, but there are all sorts of things come out. I'm dealing with the insolvent estate of a nightclub of a certain persuasion, shall we say, in the West End, where there are ladies popping out all over the world, from Brazil, from Australia, and elsewhere, who have had children with said nightclub owner and are claiming under various provisions and matrimonial provisions and I'm not going to go into all the details on the claims because that would be prejudicial because some of these matters are still continuing, but various claims that are made in relation to the nightclub owner. I have another one where we have a personal representative who appears to have used estate money to pay off liabilities they say were liabilities of the deceased, but turn out that they are potentially liabilities rather of the personal representative. But very simply, and I've got another one where we have a deceased where the mistress has popped out of the woodwork and is also making a claim for relief from the family court, or at least was, and now it's been dealt with in the insolvent estate. All sorts of things do pop out of the woodwork post-death, because obviously there's no point holding back at this point, so the truth certainly will out. Well, I hope that everyone listening found that informative. In summary, insolvent estates can be a bit techy. They're not a million miles away from normal bankruptcy in many senses, and those familiar with conduct of normal bankruptcy can take comfort from that. But there are some extremely important differences and lots of little technical differences that one should take advice on in many circumstances. But the key warning I should like anyone listening to take away is, if one is looking at an estate of doubtful solvency, or if one is advising an aged client who may or may not be insolvent, or starting to wish to dispose of assets and maybe of doubtful solvency, to really consider taking specialist legal advice or to go and speak to an insolvency practitioner with a specialism in this area, because it can have extreme consequences and extremely harsh consequences, in that payments over many years, all validly incurred with lots of hard work, all have to be paid back to the estate. Well, thank you everybody on this rainy day, well certainly in London, for listening. If anyone has any questions or wishes to contact me in relation to any matters that they're dealing with or concerned about in light of the contents of this presentation, I'd be delighted to hear from you. Thank you very much.